Good afternoon, everyone. Just wait for a few more seconds just to see if there are any more people joining. Great, well, let's start. Good afternoon, everyone. My name's Simon Murphy. I'm a property litigation and housing management partner based with House Percival in Cambridge. I'm joined today by Molly Baxter, who is a housing management trainee with the firm. We're going to talk about disrepair for this housing snapshot. So we're going to just go back to basics and talk about what is disrepair? What are your statutory obligations in relation to disrepair? What's the definition of disrepair? We're going to move on to think about how you can deal with disrepair claims, and we're going to think about commerciality, and we're going to think about what are issues that you face in those disrepair claims, such as the weaponization of records and how you can best deal with that. So without further ado, I'm going to hand you over to Molly, who's going to deal with landlords' repairing responsibilities.
Thank you, Simon. The landlord's responsibility in relation to disrepair comes from both implied and express obligations. So when looking at a landlord's repair responsibilities, you should first look at the lease agreement. In the agreement, you would expect to find information on what the landlord and tenant are responsible for and the standard of repair that is expected. With social housing, there may be some additional express responsibilities in the lease. Obligations are also implied into every tenancy agreement by statute. So Section 11 of the Landlord and Tenant Act implies an obligation to keep in repair the structure and exterior of the property and keep in repair and proper working order the installations, for example, for the supply of water, gas and electricity, sanitation, space heating and heating water. The structure and exterior of the property has been taken to include the walls, windows, roof, the access steps and path to the property, and in some cases, the internal wall plaster. Gutters, drains and external pipes are expressly included. You cannot opt out of these obligations, and where there is conflict between the tenancy agreement and statute, the statutory obligations will prevail. Statute indicates the minimum level of responsibility, and the lease agreement can add enhanced but not diminished responsibilities. And the landlord must carry out repairs at their own cost, and they are not permitted to charge the tenant for the cost of repairs or recover through the service charge. So we'll move on to the fitness for habitation. There is a real focus on damp as an issue. Any damp that is identified needs to be fixed, and properties that are prone to damp need to be inspected regularly. The test for something that is unfit is found in Section 10 of the Landlord and Tenant Act, and there are 10 factors which the court will have regard to when they are assessing the fitness of a property. These include things like freedom from damp, the internal arrangement of property, which is, for example, we've dealt with claims where the property has subsidence, which has prevented doors from shutting and prohibits the enjoyment of the property, and things like ventilation. So installing exterior fans within, extractor fans, within a kitchen can help to prevent damp issues in the property. There are 29 listed prescribed hazards in the Housing Health and Safety Rating Systems regulations. This starts with issues of damp or mould and extends to things like excess cold. Section 10 states that a property is only unfit if the property is so far defective in one or more of these matters that it is not reasonably suitable for occupation in that condition. So this is a high hurdle. However, what is reasonable is judged on a case-by-case basis. For example, what is fit for a tenant with no health conditions may not be fit for a tenant with a disability or a respiratory condition or severe asthma. If a landlord is made aware of a tenant's health condition, it should pay special attention to how this may affect the fitness of the home. I'll now pass on to Simon for standard of repair.
Thanks, Molly. So the standard of repair that is expected will be assessed on a case-by-case basis. But regard needs to be given to the character, age, and prospective life of the premises. But even if you've got some premises which are kind of due for demolition for one reason or the other, or one reason or another, and the prospective life of the premises is short, that doesn't justify leaving a tenant in a situation of material discomfort. When you've done the works to get rid of the disrepair, there's also an obligation to make good any damaged decorations and to redecorate after completing the repair work. There's a real focus on damp and mold in the press, as Molly has said, and the courts. So, if there are areas of damp and mold at the property, you need to get on with it, and you need to go in and fix the damp and mold as soon as you can, and to repair the damp and mold, I should have said, as soon as you can. If the tenant refuses to allow you access to carry out the repairing works, then you need to show that you have made every effort possible to get in, including applying for an access injunction. So, send letter 1, letter 2, letter 3, make your application to the court. If the tenant still doesn't allow you in, go back to the court. If you don't do that, the Ombudsman will be on your back. Looking now at what's outside the remit of landlord's responsibilities. The landlord is not responsible for carrying out any works or repairs that are needed due to the tenant not using the property in a tenant-like manner. So this would include things like the tenant not using the heating or ventilating the property properly. It might also include things like the tenant causing damp and mold by drying clothes inside or by having cluttered rooms or hoarding. However, you need to look at the tenant's situation before assessing this. For example, in an apartment where there's no outdoor space and no space for a tumble dryer, drying clothes indoors would be entirely reasonable. Also, I think, if you've got a hoarder or a tenant with severe mental health problems that doesn't feel able to open the window, you need to deal with mold and damp issues that arise because of that and maybe put in an expel air. I don't think a court would find it reasonable not to remedy the disrepair in those circumstances. Any other breaches of covenants may also provide a defence. For example, if the tenant is on the one hand saying the property is unfit, but on the other hand denying access to the property to remedy the unfitness. But as I've just said, as a social landlord, you're under quite a high duty to gain access, and if you don't comply with that and you don't apply for an access injunction, etc., then you're going to be criticised by the Ombudsman. Finally, the landlord doesn't have to keep in repair or maintain anything that the tenant is entitled to remove, such as kitchen appliances, unless, of course, in the lease agreement, it provides that the landlord is responsible for those items. I'm going to hand back to Molly now, who's going to talk about the pre-action protocol.
Thank you. So the pre-action protocol, this is a specific protocol for dealing with housing condition cases. It applies to residential property in England only and relates to claims in respect of poor housing conditions. It describes the condition that the court will expect parties in a housing conditions claim to have engaged in prior to the start of proceedings. It is intended to encourage the exchange of information between parties in the hope an early resolution can be reached. The court has the power to order parties who have unreasonably failed to comply with the protocol to pay costs or be subject to other sanctions. Before commencing the protocol, landlords should be aware of any poor housing conditions and given the opportunity to resolve it. The protocol should be used where the internal disputes resolution process has been exhausted, rather than as a means of notifying landlords of issues in the first instance. It is really important that when a landlord receives correspondence initiating the protocol, that they do not then disengage from either the internal complaints procedure or the repair issue itself. Commencing the protocol does not constitute legal proceedings. Following the death of Awab Isaac, the Housing Secretary Michael Gove warned landlords that they must not hide behind the legal process when responding to damp and mold complaints, and the court doesn't look favourably on landlords in cases where repair works have stopped during the pre-action protocol. Instead, the best course of action once a landlord becomes aware of the initiation of the protocol is just to go in and inspect the property and complete the repairs as soon as it is possible to do so. The case of Watson against Bristol demonstrates the importance of using the complaints procedure prior to commencing the protocol. And a tenant had an application refused where the complaints procedure had not yet been exhausted, and as a result, it wasn't desirable to order disclosure at that stage. The protocol also reiterates that alternative dispute resolution can be and is encouraged to be pursued at any stage. The pending decision in Churchill against Merthyr Tydfil may see ADR become a mandatory requirement where a claimant who unreasonably refuses to engage in ADR in breach of the requirements of the protocol can be precluded from bringing or advancing a claim in court. So we'll move on to legal proceedings. If an agreement is not reached between the parties, then the case may go on to legal proceedings. There are 4 points which the tenant must persuade the court in a housing conditions claim. Firstly, there must be an actionable defect, which we discussed earlier. Secondly, the landlord must have been put on notice of the issues, or in other words, they must be aware of the repair issue. This is the most challenging issues for landlords, as notice can be either actual or constructive. By actual notice, we mean this is where a landlord has been made aware of the issue, either via the complaints procedure or a telephone call or an email. And constructive notice is where a landlord knew or reasonably to have known about a repair issue. So, for example, if there's been an inspection of a property since an internal problem first showed, provided that it was discoverable by the naked eye, then a landlord can be considered to have constructive notice. So if you visit a property for any other reason and see something that may need repairing, you are on notice of the issue. Notice or knowledge can be imputed. So this means if a contractor has been made aware of the issue, then the landlord will have been put on notice. And the third and fourth points are that there must have been a failure to repair within a reasonable time, and there must be a loss, both of which we will discuss later on in this presentation. Moving on to access. So in order to fulfil its repair obligations, the landlord must be given access to the premises. Paragraph 7.6 of the protocol states that tenants must allow the landlord reasonable access for inspection and repair in accordance with the tenancy agreement. The landlord should give reasonable notice of the need for access, except in a case of an emergency, and the landlord should also give access to common parts as appropriate. For extensive works, you should ensure that the tenant knows the full extent of the work that is being performed, as well as the time frame you expect the work to take to complete. If you are not granted access upon request, a landlord should make 3 genuine attempts to gain access to the property before seeking a court injunction. This would usually be enough for a judge to make a ruling in the landlord's favour. These attempts should be made in writing, and a record should be kept of how access is refused. Sometimes you will come across solicitors who are advising residents to deny access to complete repairs where there is an ongoing dispute. However, the case of Liverpool Mutual Homes against Mensa granted a landlord an access injunction with costs in a case where access was being refused by a tenant. And the judge found that the dispute does not make it reasonable for a landlord to refuse access. Where there may be mental health issues at play, which is restricting the landlord's access to a property, for example, where there is a case of OCD or psychosis, you should consider involving social services before taking a more heavy-handed approach. But you do have to balance this where there are high risks, for example, if you can't complete a gas and safety report due to hoarding, and the hoarding is causing a fire hazard. In cases such as these, then reports from specialists such as the fire service would help to strengthen a case for an application for an injunction. And then dealing with complaints. In October 2021, the Housing Ombudsman issued a report, Spotlight on Damp and Mould, in which they made a number of recommendations. Firstly, it recommends that a blame mentality should be avoided. As discussed earlier, it's not the landlord's responsibility to repair issues where they are caused by a tenant failure to occupy in a tenant-like manner. However, this report emphasised the importance of moving from inferring tenant blame to taking responsibility. It recommended that the landlord carry out thorough investigation, and until there is a good evidence to suggest that the tenant has caused the issue, the landlord shouldn't be jumping to that conclusion, and actions that place the onus solely on the tenant should be avoided. When communicating with tenants, language which leaves tenants feeling blamed should be avoided. You should give the notice that is specified in the tenancy agreement, but please be flexible around the tenant's work and other commitments, and do not turn up unannounced, as void visits just don't help build a good case if a claim is brought in court. To manage expectations, just keep in contact with the tenant throughout the process. Even if the news isn't good news, communication will help reduce tenant frustration, and it will be looked at favourably by a judge. When it comes to timescales, at the moment, the landlord has a duty to repair in a reasonable time. This amount of time is not defined in statute and will depend on what the problem is and how serious it is. Factors such as how extensive the works are, the availability of materials, and the cost of the works will affect what is reasonable. This can be quite difficult to argue and defend in court, and therefore the best way to defend claims or avoid claims altogether is by dealing with disrepair without delay. In social housing, a landlord can be held accountable by the Housing Ombudsman for the length of time taken to fix problems within a home. And since the death of Awab Isaac, which was caused by damp and mould in his home, amendments to the Social Housing Regulation Bill received royal assent in July this year. The Act introduces strict time limits for social landlords to address hazards and empowers social housing tenants to request information from their landlords, promoting transparency and accountability. It also introduces stronger regulator enforcement powers, as well as requiring social housing managers to possess specific qualifications or at least be actively working towards gaining them. There is now a phase of consultation, and it is expected that regulations will be published and come into force in 2024. So we'll now move on to Simon, who will discuss records.
Thanks, Molly. So it's important that a landlord has a means of recording and maintaining all communications with tenants. You're required to keep detailed records of works done to the property and records of any complaints made. This obviously includes communication that is unrelated to repair issues. For example, if there is evidence that a tenant has been communicating with a landlord regarding other issues relating to, say, neighbourhood disputes or ASB, and they don't mention their repair issues, this could be evidentially useful in defending a claim. But on disrepair, it's important to keep in mind when working on any record that it could be used in court as evidence. Inaccurate records run the risk of being weaponized. For example, a photo without anything to show the scale of the disrepair could make an issue look substantially worse than it is in reality. If we're talking about, say, a small line of mould along a bath seal or near a window, maintenance workers should consider holding up a tape measure to a damp area to scale the photograph. But if damp issues are particularly bad, it's probably best not to take a photograph of it. In these situations, it would be advisable to only take a photograph of the completed work, and when commenting on the report, to use when commenting on leaving a note of the visit, to use language such as mold found upon inspection, maintenance works to be scheduled. And then it's important that the works to remedy the disrepair are urgently escalated so that the mold and damp is got rid of as soon as possible. Often the focus is on training your own staff. However, when it comes to a court case, you may find yourself relying on notes taken by one of your subcontractors. Subbies are often working against strict time pressures and have a high workload. These conditions can often lead to the deterioration in the quality of note taking. So you should consider offering training to your subcontractors as well, to ensure that they know the law, to ensure that they know that their notes could be used against the housing association in proceedings, and to make sure that they know the importance of keeping good and accurate records throughout the works being completed. At the very least, a landlord should be routinely checking any documents received from subcontractors and their own internal maintenance team, and clearing up any errors and any areas of uncertainty immediately. Okay, so what happens if things have gone wrong, there is disrepair, you think it's actionable disrepair, what sort of damages are you facing? Well, if the tenant can show that the disrepair has had a sufficient impact on their enjoyment of the property, and that they can prove the 4 points we discussed previously, then they're going to get damages. And the first point to note is that the rent of the property is used as a basis to calculate compensation. So a percentage of the rent that was paid while the tenant resided in the property with disrepair will be the starting point. And the actual percentage that will be awarded will depend on the severity of the disrepair. So a completely uninhabitable property will result in 100% compensation. However, that's extremely rare. Normally, compensation ranges between 25 to 50% of the rent of the property. In addition, the tenant will be able to get special damages, So they're damages for monetary losses incurred directly because of the disrepair. So that can be things like spoiled items of furniture, spoiled decorations, loss of earnings, if there's missed work to facilitate inspections or repair-related appointments which have later been cancelled, they're claimable too, as are increased utility bills. For example, from running dehumidifiers to dry out the property following a leak. You're helped by Section 6 of the Limitation Act. So this provides that damages can only go back 6 years. So any damage to property that predates this will be time barred under the Limitation Act. There will be a fixed legal costs regime, but it's been announced that the fixed recoverable costs regime will not include housing disrepair cases until 2 years have passed, because they're behind on the implementation of the fixed costs regime. So until the fixed cost regime has come in, the issue of commerciality of settlement becomes increasingly important, because the legal costs that you will incur in defending disrepair claims and in paying some or all of the claimant's costs are likely to far exceed the cost of repairs and the damages combined. If there is some disrepair, and so the tenant has brought a claim which is partly justified and partly unjustified, it's likely that they'll get some or all of their legal costs, and you'll end up having to pay all of your legal costs. So you need to think really carefully about dealing with these cases commercially, because if you're facing a claim for, say, £1,750, that is a significant claim, but the legal costs in defending it are much more likely to be £5,000, £10,000 or £15,000. Is it really worth spending that amount of money defending a claim which is of much less monetary value? However, if you have a tenant who is very vocal, should we say, and will tell all of their neighbours about the fact that they have been given some compo from their landlord, then you probably need to deal with them in a slightly different way, so that disrepair claims are not seen as a cash cow throughout your developments. So I think essentially the advice there on commerciality is that each case should be assessed on its own individual merits and facts, but that you really need to be careful about spending vast amounts on defending claims when it may be cheaper to offer a nuisance payment to the tenant to make the claim go away. So I'm conscious we've only got 1 more minute. So to conclude, the key takeaways are that you really need, as I'm sure you're aware, to be focusing on and prioritising damp and mould issues. You need to complete regular visits to monitor the properties where damp and mould is present, and you need to be scheduling works without delay where damp or mould is discovered. If access is denied, you need to be following the process through to injunction in order to gain access and resolve the issue straight away, even if there are Equality Act issues. The Ombudsman will be on your back if you don't do that. So you need to prove that you have gone through the process and proceeded to get rid of the damp and mould in a fair way. So, if the tenant is vulnerable and doesn't like contractors going in unsupervised, then you need to put in place a plan to make sure that it's dealt with sensitively. But you do need to go in and resolve the damp and mould, and if you don't do that, you will be challenged. You need to, secondly, as I've just said, you need to have a commercial approach when dealing with settlement, and you need to understand the benefits of settling early. And then finally, keep an eye out for the new costs rules coming into force in 2024, if they actually do come in. Normally we open up for questions, but I'm conscious it's lunchtime and we promise that these slots will be half an hour only. So I'm not gonna take any questions now, but if you have any questions for Molly or I, please send us an email and we will try and answer your questions. But thank you very much for co-presenting with me, Molly, and good
That's it.
to
Thank you.
thank you for attending our snapshot, and Estelle and JP will be doing the next one, which I think may be in the new year. So if it doesn't seem too early, Merry Christmas, and see you next year. Thank you. Bye.